Well, hello there and welcome. Tonight we are going to talk about tort law. I always thought the word tort was an odd name for a branch of law. The word tort, I don't know about you, but it reminds me of a nice, rich chocolate cake with lots of icing. Sadly, that's not on the agenda for today. So, let's go forward and talk about what tort law really is. It comes from the Latin word tortum, meaning to twist. It is the equivalent to the word wrong in contemporary English. So a tort, specifically speaking, is conduct arising to a tort is not straight or lawful, but is twisted, crooked, or unlawful. And a wrongdoer is called a tortfeasor, and that is a person who has done something to harm the rights, property including reputation, or the physical body of another person. So let's think about this. We live in a civilized society, and a civilized society imposes a duty by way of law in each person to respect the legal rights vested in all other people in that society. So the name of that body of law is tort law. It gives people a legal means to be compensated and to have their day in court against a person who violated their personal rights in some way. A tort is a harm against the person, property, image, or rights of another person, as opposed to a crime. A crime is an action that violates the laws of the state. State meaning literally state and country. While torts and crimes are different bodies of law, the conduct that gives rise to a tort may also give rise to a crime or a criminal act. So what exactly do I mean by that? Well, what I mean is it's possible for a person to do something or act in a certain way and be liable both in civil court for the tort or the violation of individual rights of another, and in a criminal court for the violation of a crime, of a criminal code written by the state. Example, some of you will remember O.J. Simpson and the situation with the murder of Nicole Brown Simpson and her friend Ron Goldman. You may recall that O.J. Simpson was tried first in a criminal court for murder. He was found not guilty. Shortly thereafter, he was tried in civil court with Mr. Goldman's family bringing suit for the tort of wrongful death. Essentially the same evidence, two different courts, and in the civil suit he was found liable, which is the civil form of guilty. So you may wonder, well, how come he was not guilty in a criminal court and found liable in a civil court based on the same evidence? Well, in criminal court in the United States, we take the verdict of guilty very seriously. You know, we're innocent till we're proven guilty in criminal court. And when you go to court for a crime, you could be, as a defendant, you could lose your freedom, you could have financial penalty assessed against you, or you could lose your life in a life death penalty trial. So those are pretty bad things. Those are pretty onerous outcomes. So when you go to criminal court in the United States, the plaintiff or the state must bring a case that proves their case beyond a reasonable doubt. The jury must be 99% sure or more that the defendant indeed did commit the alleged crime. That's a very high burden of proof. It's hard to prove anything 99% or more. But in a civil court, the penalties assessed against a defendant in a civil court are They will either have to be ordered by the court to do something, to return something, or pay a fine, or refrain from doing something, but there is no danger of losing one's life as a result of a civil proceeding. So, the outcome is not as onerous as for the criminal court. So the burden of proof is less. It is by a preponderance of the evidence, which is 51% or more. So the jury has to decide, well, it's more likely than not that he's responsible for this. So, yeah, it's easier to find a liable verdict in a civil court than a guilty verdict in a criminal court. The nuts and bolts of torts. So in this lecture, we're going to discuss the following torts: assault, battery, medical battery, false imprisonment, intentional infliction of emotional distress, and they call it IIED for short, trespass to land, defamation and slander, invasion of privacy, and breach of confidentiality. And let's not forget negligence. So each tort on that list has its own set of elements or parts that define that tort, and all elements must be proven by the plaintiff or the alleged victim in order for the defendant or alleged tortfeasor to be found liable for committing the tort. You're going to find throughout your life, as you read about torts, which I know you're going to do because it's such a fascinating topic, that you will see categories as intentional torts, quasi-intentional torts, unintentional torts, all kinds of things. Just bear in mind that tort law is a matter of state law. Each state defines its own tort law. So, in order to simplify all these categories, which can vary from state to state, from publisher to publisher, I would just like you to know that some torts can be committed without intending to, example, trespass to land, and some torts require the person to intend to commit the tort in order to be found liable. And we will go through those as we go through the torts one by one. Let's look at an example using battery. For a person to commit a tort of battery, he or she must make harmful or offensive physical contact with another person, who is the victim, which has no legally justifiable reason and was not consented to by the victim. Okay, that's a big messy paragraph. Let's break it down a little more neatly. The elements of battery requires physical contact or touching of a person, and the touchee must have not consented to the touching, and the toucher has no legal justification for the touching, and the touching is considered harmful, offensive, or noxious by the person touched. In order to prove a tort of battery, you have to have every single one of those elements. Let's look at an example. An example of tortious battery. Ben is a 6th grade student, and Barbara is his autistic classmate, who becomes agitated when she is touched. Ben is walking past Barbara's desk and smacks Barbara in the middle of her back. Do you think we have a battery here? Just as a matter of hint, children can be held liable for committing torts. The answer is yes. Ben committed tortious battery on Barbara. All of the elements of battery are here, in that Ben physically touched Barbara, so there was a physical touch, and Ben had no legal reason to touch her, no legal justification, and Barbara did not consent to the touching, and Barbara considers this touching offensive. So we have all the elements here of a tortious battery. Let's look at medical battery. So medical battery is the physical contact or touching of a person, and it must be a touching in the course of providing health care, and the touching must not have been consented to by the touchee or plaintiff, so it is outside the scope of consent, and there is no legally justifiable reason for the touching. How about we look at an example? Dr. Mary Beth is an orthopedic surgeon, and Mike Benson is scheduled to have a left knee arthroscopy today. That's when they make a small incision, inflate the joint, or kind of distend the joint with fluid running through it, and they put a little camera in there and look around, and they can do some shaving and some snipping and even suturing in the arthroscopy. So Mike is in the operating room. He's under general anesthesia, and his right knee is prepped. Dr. Mary Beth enters the OR. She drapes out the right knee, makes the incision, inserts the scope. Oops, the knee looks normal. Why am I operating on a normal knee? Dr. Mary Beth asks herself. Well, circulating nurse needs to look at the consent. Well, whoops, because the consent is for the left knee. Well, what do you think? Is this a medical battery? Yes, it is an example of medical battery. All of the elements of medical battery are present in that. Dr. Mary Beth performed a physical touching of that right knee in the course of providing health care. She thought she was providing health care, and she operated on the right knee, which was the wrong knee, and the scope of the consent that Mike signed was for a left knee arthroscopy. So the right knee was outside of the scope of consent. And there was no legally justifiable reason for Dr. Mary Beth to operate on the right knee. Let's look at the elements of assault. Assault happens when, the tortious assault happens when a person causes fear in another person. And that fear must be reasonable considering the circumstance. And the fear must be of a harmful, offensive, or noxious physical contact. And the threat must be of imminent contact, about to happen any second now, not at some vague time in the future. And the contact must be without the victim's consent. Let's look at an example. Tina is angry because Annabelle made a pass at Tina's boyfriend. Tina says to Annabelle, "You know what, girl? You better run as fast as you can because I am going to mess you up and your life is now over." Then she pulls out a knife, raises it, and starts walking towards Annabelle. And Annabelle is very afraid. Who wouldn't be? What do you think? Do we have an assault here? The answer is yes. All of the elements of assault are here. Tina caused fear in Annabelle. And the fear is reasonable. A reasonable person would be afraid in the same situation, since Tina made a verbal threat and she appears to be acting on the threat right now. It is imminent. And, it is reasonable. And Annabelle is afraid of the harmful contact, primarily with Tina's knife. And the threat of being cut is imminent, in that Tina is presently approaching her with the knife. And Annabelle did not give consent to Tina to touch her with the knife or to harm her. Let's look at false imprisonment. This happens when a tortfeasor intends to confine a victim to boundaries fixed by the tortfeasor. Notice the word intend there. This is a tort that requires intent in order to find a person liable. It can't happen by accident. And the tortfeasor confines the victim within those boundaries, and the victim is either aware of the confinement or the victim is harmed by the confinement, and there is no legally justifiable reason for the confinement. A little detail here: if you confine a minor person, a child, against the will of their legal guardian, that also is considered false imprisonment. Let's look at an example of false imprisonment. Frank is a mentally competent 78-year-old man. He lives with his nephew, Ian. Frank wants to go visit his girlfriend, but Ian hides Frank's car keys and cell phone and disables the landline, so Frank is not able to call for help to get out of his home. Frank is looking for his keys and his phone and is trying to use the landline, but it will not work. What's your opinion? Do we have the tort of false imprisonment here? Yes, we do, because Ian intentionally confines Frank to his home by taking away the car keys and all potential communication for help. And there is no legal reason for the confinement, and Frank is aware of the confinement. Oh, I think I said that. Sorry. Anyway, yeah, it's all false imprisonment. Let's look at the elements of intentional infliction of emotional distress. Person number 1 acts in such a manner as to cause severe emotional distress in person number 2. And person number 1 either intended to cause the distress or acted recklessly without regard about the possibility of distress being caused. That's called reckless disregard. And the conduct was outrageous by society's standard. And person number 2 suffered severe or extreme emotional distress, and the distress was caused by defendant's conduct. So we have causation there. So we have all the elements listed here for intentional infliction of emotional distress, or IIED. Let's look at a story. This is a real-life story. All of them are, but this is actually a legal case. Dana versus Oak Park Marina. Defendant placed a video surveillance camera in a ladies' changing room and bathroom at a marina. Approximately 150 to 200 women were videotaped without their knowledge or consent, and they had been changing clothes or using the toilet while they were being taped. Now, the defendant used the tapes for his own personal entertainment and also showed them to third parties for entertainment. What a fun guy. Well, when the defendant's actions were publicized, some of the victims discovered this and experienced severe emotional distress. Well, what do you think? Did the defendant's actions create a tort of intentional infliction of emotional distress? The answer is yes. The court did find IIED in this case because the defendant acted recklessly with reckless disregard to the victim's emotional status when he taped them in the bathroom and changing room. And taping people in bathrooms and changing room is rather considered outrageous conduct by society's standards. And the defendant's conduct caused severe emotional distress in his victims. So there is causation resulting in, of course, the severe emotional distress. Let's look at elements of trespass to land. As I mentioned earlier, there is no intent required. You don't have to know that you're trespassing on somebody's land to commit the tort. So person number 1 enters the land of person number 2 and either intends to enter the person's land or doesn't know that he's that he's entering another person's land. And person number 1 does not have the consent of person number 2 to enter the land. In fact, I committed trespass to land, at least probably on one occasion that I know of. Probably we've all done it. If you've ever cut across somebody's yard walking home from school and you don't know whose yard it is and you don't have their permission, you most likely did commit trespass to land multiple times in your childhood alone. But they didn't sue you for it, and it's not something that people often sue for. But I remember years ago I had a horse at a barn in Lewisberry. It was a boarding stable, and they had trails, and I took my horse out and was riding on trails. And we saw this really nice field that we hadn't been on before, so we just followed the path onto the field. We're having a grand old time, and lo and behold, there stands a man with a shotgun. Well, imagine my feelings. I pulled up to him and stopped, and I just looked at him, and he said, "You know, this is my land." I'm like, "No, I am so sorry, I did not know it was your land." And he went on to say about how some of the children in the neighborhood had been riding all-terrain vehicles on his land, and they were tearing up the ground. So he no longer tolerated anybody on his land, on horses or all-terrain vehicles or anything. And except for the gun, he was a very nice guy. So I promptly left his land and did not go back down that path again. But I did enter the land of person number 2. I did not know whose land it was, and I did not have his consent to enter the land. So, ladies and gentlemen, I am a tortfeasor. On to the next. Let's look at the elements of defamation. Person 1 makes a false statement about person 2, and the statement is made available to at least one other person besides person number 2, and the intent of making the statement was either malicious, or the person number 1 acted without caring whether the statement was the truth, acted with reckless disregard, and the statement was of public interest, and the reputation of person 2 was injured as a result of the statement. Let's look at an example. Diana is an accountant, and she is angry with her boss, who happens to be gay. So she creates a false identity on Facebook, posing as her boss, and makes entries about what it's like to have AIDS and to be a male prostitute. For the record, boss does not have AIDS and is not a male prostitute. Boss also happens to be a very prominent member of the community, and his Rotary Club membership is canceled as a result of the rumors that abound. Well, what do you think? Did the tort of defamation occur here? Yes, all of the elements of defamation are here. Diana made false statements about boss's sexual escapades, his habits, and his health status. And her intent was malicious, and public interest was involved because she indicated that he was spreading AIDS, and the boss's reputation was injured by Diana's statement, and he was kicked out of the Rotary Club. So, yes indeedy, we have all of the elements of defamation here. In order to have a tort of invasion of privacy, we must have the following elements. Defendant invades plaintiff's personal or private space, and it must be a physical intrusion, and this type of intrusion would be objectionable to the ordinary reasonable person, and defendant's actions must create a substantial interference with plaintiff's privacy, and it must occur in a place where plaintiff has secluded him or herself, or the defendant used his senses to overhear or see plaintiff's private affairs, or defendant did some kind of investigation into plaintiff's private concern. That's a lot of elements. Let's see what we have here for a case study. We have a real case. Licit versus Doctors for Medical Liability Reform and St. Joseph Hospital in Atlanta, Georgia. Mrs. B had passed away by the time this lawsuit was brought, but it was brought on behalf of her estate by her daughter. So, Mrs. B, let's look at the situation. She's an elderly lady. She was taken to the emergency room of hospital for partial paralysis and sudden mental changes. Political group had been taping ER patients at hospital that day for the purpose of making a documentary about patient care. Mrs. B was videotaped with part of her face drooping, paralyzed on the left side of her body. She had a non-rebreather oxygen mask on, and an intravenous in her arm, and she looked very afraid. And the footage showed her being lifted from a stretcher by 5 hospital employees onto a hospital bed. Political Group later used the footage of Mrs. B on a nationally aired documentary. Neither Mrs. B nor her representatives were asked, nor would they have signed a release, as Mrs. B was a very private person and never permitted her picture to be taken without her consent. Well, what do you think the court found? Was this an invasion of privacy? In fact, it was. For the purpose of law, a hospital and ambulance are considered by law to create a reasonable expectation of privacy in patients, not to mention all the laws surrounding the situation and the patient's Bill of Rights. Mrs. B's privacy was violated by political's actions, and an ordinary, reasonable person would consider the videotaping to be objectionable when one is so ill and in such a vulnerable state and unable to voice objections. And the interference was substantial because she was sick, and then they shared her image of her being very sick and vulnerable on public television. And the defendants did use their visual and auditory senses to observe and record Mrs. B's plight. Let's look at elements of the tort of breach of confidentiality. Person A makes information about Person B available to a third party, and Person B had a reasonable expectation that Person A would not share that information. For example, a patient talks about their protected health information to a healthcare provider. And Person A did not have a legal reason to share the information, and Person B did not give consent to Person A to share the information. Let's look at an example. It's one of my favorite examples. Britney, a famous singer, experienced a psychiatric setback. She shaved her head, behaved erratically, and eventually was admitted against her will to a big hospital psychiatric ward in California. Nurse Ratched works at the pediatrics ward at Big Hospital. Note I said the pediatrics ward. And Nurse Ratched is not involved in Britney's care. However, Nurse Ratched uses her passcode in the Big Hospital computer system to access Britney's medical records and gossips with others about the things she learned from Britney's electronic health record. Well, what's your opinion? Did Nurse Ratched breach Britney's right to confidentiality? Yes, she certainly did. This is a breach of confidentiality tort. In that, Nurse Ratched accessed and shared information which was confidential when she read Britney's record and gossiped. And Britney did have a reasonable expectation of confidentiality for her PHI. We aren't going to go into why, you already know that. And Nurse Ratched had no legal reasons to access Britney's PHI because she was not involved in Britney's care. And Britney did not consent to Nurse Ratched's conduct. Okay, now on to negligence. Anytime we are on duty in healthcare, our actions are subject to a duty of care. This is where the concept of standard of care comes in, and the concept of scope of practice, standard of care, and patient's rights all come together in this concept. If we violate any of those, if we breach any of those, it is possible that a negligent tort action might have occurred. So, according to the study guide for your certification exam, I'm using their terminology, the 4 D's of negligence: duty, derelict, direct cause, and damage. And I think that's a nice way to memorize it, or to remember it. Okay, you have a duty of care, We have a derelict in the tort of negligence. We have a failure to perform our duty, or a breach is another thing that it's called. But that's not, doesn't start with a D, so it wouldn't fit to call it a breach. So we're going to call it a derelict. And we have a direct cause, causation, injury. Some kind of injury to the patient occurs as a result of the failure to perform that duty, and a damage resulting from the failure to perform the duty. When a healthcare provider acts in a negligent manner, it is called medical malpractice, nursing malpractice, or just plain malpractice, depending on who is the negligent party. There's usually more than one. It's usually when you have a situation, it's more than one person made a mistake and it kind of snowballs. So it can be under the umbrella of medical malpractice, or it can be more specifically stated. It's all negligence in a healthcare arena. So let's look at a case study in medical malpractice. It is the Carolyn Savage case. Mrs. S. and her husband had a history of fertility problems, as did Mrs. M. and her husband. The couples did not know each other. They both lived in the same state, both couples. And they had both gone to Dr. P., who is a fertility specialist. Now, both couples had embryos created from their respective genetic material and had the embryos frozen for future use. So sometime later, Mrs. S. decided to have an embryo implanted to carry to term, and she went to Dr. P. for an in vitro implantation of an embryo. But some kind of labeling error was made, and Dr. P. accidentally implanted one of Mrs. M.'s embryos into Mrs. S.'s uterus. What's your opinion? Do we have a case of medical malpractice here? The answer is yes. We do have a tort of medical malpractice. But was there a lawsuit? No, I don't believe there was. These people chose not to follow through with a lawsuit. But we do have the elements here. Dr. P. had a duty to perform the IVF on Mrs. F., the in vitro fertilization, with the proper procedure, the proper embryo, and so forth. That's a duty, just plain old duty of care. And he was derelict and breached his duty when he implanted the incorrect embryo. Was it Dr. P.'s fault that he implanted the incorrect embryo? No, not directly. It was mislabeled. He implanted the one that was labeled properly. But because he was responsible for all the things that happened in his medical practice, it is considered his derelict. So he is responsible for the employee who mislabeled it, so indirectly he is still considered negligent. It did result in his implanting the wrong embryo. And the breach or derelict directly caused Mrs. S. to be pregnant with Mrs. M.'s child, and to be compelled to carry a pregnancy in which she could not keep the child. And the damage is in the wrong child pregnancy, and the opportunity cost of carrying her own child, and the many ethical dilemmas that Mrs. S., Mrs. M., and their families had faced thereafter. And there is an interesting video about this case, which is your ethical case for tonight, and it is on abcnewsgo.com, called Embryo Mix-Up: Grieving a Baby Boy Who Did Not Die. And it is a 2-minute and 40-second video, but it gives you a little taste of what these families went through. And that is the end of that. Have a good night.